Hi, I'm going to take on the question of rights not being protected effectively in the UK. So we're analysing and evaluating this statement, 25-mark question. I'm going to use this model, so I'm going to talk about an introduction potentially, then 3 different points, the arguments for and against of each, and then finishing with a conclusion, maybe how you would approach that. In terms of reading around this topic, I would suggest there's a number of different articles which would be helpful. This one, which talks about the comparisons between the US and UK Supreme Courts, is definitely worthwhile when you're considering examples of rights that have been protected most recently. There's a couple of articles which look at the pros and cons of the Supreme Court and will touch on rights, such as this one, has it changed anything? Or this one, which looks at judicial review in the UK and the role the Supreme Court has played. And then more recently, there's this debate article in Politics Review, should the UK have a Bill of Rights, which looks at the arguments, yes, saying that the Human Rights Act presently is not enough, or then going against and saying they're adequately protected by the Human Rights Act. So it's definitely worth a read, just as a context and perhaps with a little bit more analysis that you could utilise. So where do we start? Well, in terms of the introduction, this could either be seen as a constitution question or a Supreme Court question because it touches on both, really. In terms of definition of terms, well, you start off with the fact that any democratic country would expect to have the protection of individual rights at the heart of its constitutional arrangements. The debate in the UK is really how effectively minority rights are protected when we don't have a Bill of Rights such as in the United States. There's a concern, obviously, the executive power in the UK can be too much, and that is obviously a threat to minority rights moving forward. We balance that against, of course, the creation of the Supreme Court and other constitutional reforms which have actually enhanced the protection of rights in the last 20 to 30 years. So the first point is what? Well, you can argue that the Parliament traditionally has had a key role and the capacity to further enhance rights protection in this country. And there's arguments to back that up. We can certainly sustain it by looking at the constitutional statutes that Parliament has passed in the last 20 to 30 years, which has allowed the state to be more responsive to changes in modern society. For example, the Human Rights Act in 1998, the Freedom of Information Act in 2000, both illustrate the fact that Parliament can respond to the public's need to have greater rights. And the pace in which acts can be passed can show how responsive Parliament can be, compared perhaps to the United States, where having a Bill of Rights means that anachronistic rights such as the right to bear arms stays within those rights rather than being changed on a regular basis. Arguments against this? Well, they're not enshrined. So therefore, any acts of Parliament can be repealed by Parliament themselves, which obviously means that the protection of rights is not fundamental, and that therefore would argue quite clearly against whether or not Parliament can truly do this job. The examples of this is that government may seek to pass legislation which would infringe on minority rights. Popular legislation such as the restriction of rights against travellers or young people to attend raves, as was shown in 1994, is probably a sign that in fact a government with a large majority really has the potential to threaten the nature of rights in the society. So therefore, where does the balance of this argument lie? Well, can Parliament effectively protect rights, or is the threat of elective dictatorship of a government with a large majority too much? You'll have to make that decision. It really, I think, it depends on whether or not you feel there is a threat from a government with a large majority. Second point is to say that there are key checks on legislation being passed by Parliament which can threaten rights. So in these two areas, if you argue in favour of this, can be sustained by saying that the House of Lords as a reviewing chamber and also the Supreme Court play a role in checking the executive. The House of Lords has forced concessions from governments in the past over issues such as criminal justice and religious hatred legislation, and their unique composition, which includes previous lawyers, policemen, etc., can provide effective scrutiny over such laws. The Supreme Court also has the capacity to use judicial review to say that laws are incompatible with the Human Rights Act and therefore encourage the government to revise legislation as a result. However, if we're arguing against this, we would have to acknowledge the fact that the House of Lords and the Supreme Court have significant constitutional limitations. The Lords can only delay legislation, and the Supreme Court lacks the capacity to rule laws truly unconstitutional due to Parliament remaining sovereign, and therefore can only really be brought to the court as cases with the hope that Parliament will actually change them as a result. So we can argue that there are checks that exist in the political system, but they tend to be reliant upon government willingness to alter the details and intentions of the legislation in a desire to avoid confrontation with the Lords or the courts. The third point is to argue that the Supreme Court has a key role in independently protecting rights from government or companies acting illegally. This is the aspect of ultra vires, where we find that governments, national, legal, local or regional, and companies have acted beyond their legal power. Lord Woolf was quick to say that there's a crucial role for the independence of the Supreme Court in remaining vigilant where executive can act against their citizens in an unlawful fashion. Ministers, again, have been critical of the court, acting too often to protect minority rights at the expense of national security. You could also back this up by giving examples of recent cases of employment law, which are seen in those Politics Review articles, and more recently with the Uber case. Against this, you would have to say there are clear constraints on the Supreme Court, as they have to interpret actions based on acts of Parliament, rather than having a Bill of Rights constitutionally and fundamentally entrenched. Therefore, the government has capacity to legalise its own actions by passing laws if it's found to be enacted illegally. Also, the protection tends to be retrospective, as the court can only rule on actions that have already taken place. So where does the balance of this argument lie? Well, you'd have to acknowledge the fact that ministers have been increasingly frustrated by the Supreme Court, and that indicates that the level of challenge of the court has possibly been sufficient in actually showing that there is a level of protection of rights that exist in the country. So how do we conclude? Well, you've got to make a judgment. You've got to decide whether or not rights are effectively protected. Then what I would like you to see is whether or not you can provide the counterpoint, where you can acknowledge the fact that there's an argument which goes against your judgment. So if you're saying they're not protected, what you'd have to acknowledge is there have been key constitutional reforms. If you're saying they have been protected, you're going to be talking about the fact that actually there's still limits that on the checks on Parliament. And the fact that we have a part written uncodified constitution means that the Bill of Rights isn't entrenched. If you're in favour of this and you're saying that the rights are not protected, you would definitely be focusing in your argument on the constitutional weaknesses in the UK, as rights are not entrenched, and as they are in the US, and therefore minority groups can be threatened in times of crisis. If you're against it and you're saying the rights are protected, you're definitely arguing, I would say, that Parliament can do its job, it's responsive to modern society, and actually there's sufficient and increasing protection provided by the Supreme Court. I hope that helps. Good luck.